I hope you had a nice little break, got a little stretch in, found a snack. As I mentioned, now we're going to be joined by two attorneys with the Cassels, Brock, and Blackwell law firm out of Canada, our good friends to the north. Joining us today are Mr. Peter Henein, partner at Cassels, Brock. His practice focuses on intellectual property, including trademark and copyright matters, product liability, and class actions. He serves as the chair of the product liability group at Cassels. Joining Peter today is Stephanie Roberts, an associate at Cassels, Brock. Stephanie's practice also focuses on intellectual property, with a specialty in the trademark area. They spend a lot of time with hospitality clients in this space. We're very interested in what they have to say. They're going to be talking to us about ensuring sweet dreams, trademarks, and branding in the hospitality industry in Canada. Please welcome Peter and Stephanie.
That's great. Thanks for that introduction, Stephen. Hi, everyone. Welcome. Thanks for joining us today to talk about trademarks and branding in the hospitality industry in Canada. Taylor, we can go to the next slide, please. So I understand that I think most, if not all of you, are based in the US, but as we know, Canada is often the first international market for US companies that are looking to expand their business. For several reasons, including, of course, the close distance. Despite the proximity, trademark rights are territorial, which means just because a company has US trademark rights, it doesn't mean that they necessarily have any protection in Canada. With some exceptions, trademarks are generally governed on a country-by-country basis, which means even having rights in the US, if you want to protect your trademarks in Canada, you'll have to take specific steps to do that. So in the case of a registration, that will mean filing a trademark application with the Canadian Intellectual Property Office. So whether a company is looking to expand into Canada or if it already has a presence in Canada, it's really important to know the differences between US and Canadian trademark law, and also to be aware of key developments happening in Canada. Next slide, please. So Canada and the US are similar in a lot of ways when it comes to trademark law. In general, the governing principles are the same. Trademark law is all about protecting consumers from confusion. So a trademark should be distinctive of the company that's providing those goods and services in association with the trademark being used. There are, however, also a number of differences. One of them is the timeline. Unfortunately, the Canadian Trademarks Office is painfully slow. It currently takes about 2.5 to 3 years to register a trademark, which means currently, if we file an application today, we're not actually hearing back from the Trademarks Office for about, I think it's close to 2 years at this point. So there's a lot of backlog and there's a significant delay, which means if you intend to expand into Canada in the near future, then it's really important to get your applications in sooner rather than later. Another difference is that there's no supplemental register or provincial trademark registers in Canada. I know the US has a supplemental register where your mark can register on that, the secondary register, if the trademark is not necessarily distinctive at the time of registration. And there are also state registers, but in Canada, there's only one. It's the federal register, and that's governed by the Canadian Intellectual Property Office. There's also some things to know, some French language issues. I don't have time to get into all the details there, but it is something that I wanted to flag for you. Canada, of course, has two official languages, English and French, and there are French language laws that apply to companies who are doing business in Quebec. In general, that means that in the case of products, for example, so on product packaging, or for any advertisements and for signage, generally in Quebec, any information is going to have to be provided in French. There's an exception, however, for trademarks. If your trademark is in English and you're using it as a trademark, you don't necessarily have to use a French version of that mark. However, there's an exception to the exception whereby if you have a registration for the French version, then you are in most cases required to use the French version. So I just wanted to flag that. The other thing is that use is no longer required for registration in Canada. This is a fairly new development there was a lot of changes to the Trademark Act, the Canadian Trademark Act, that came into effect in June of 2019. And as it currently stands, you can file a trademark application, and that can actually, the mark can proceed to registration even without there being any use in Canada. That doesn't mean that use isn't important, though. Use is, of course, still very important. Next slide, please. So what do we mean by use? Trademark use has a particular meaning under the Trademarks Act. So when we're talking about goods, trademark use generally means that the trademark is actually marked on the goods themselves, or it's on the packages or the labels for those goods. For services, which are more relevant for our purposes today, is a little bit different. Use with services means that the trademark is used or displayed in the performance or advertising of those services. So advertising a trademark in association with services can be use. However, the mere advertising isn't going to constitute use. Some aspect of the services still have to actually be performed or delivered in Canada. We'll talk a bit more about that later. So why is use still important? For a few reasons. First, there's common law rights. Even if you don't have a trademark registered in Canada, but you're using it in Canada, you still obtain some rights. The rights are just more limited. More limited in the sense that, importantly, your rights will only apply in the jurisdictions that you can actually show that you've used the mark and you have a reputation there. So that means that, for example, if you're only using your mark in Ontario, you won't be able to prevent a third party from using a similar mark in British Columbia. That's the first reason. The second reason is even if you're using a mark but you don't have a registration, you can still oppose a third party application if it's confusingly similar. And then finally, there's Section 45 non-use cancellation proceedings. Next slide, please. So Section 45 non-use cancellation proceedings they're a summary proceeding that take place before the Trademarks Opposition Board rather than the courts. And what these are, this means that if a trademark has been registered in Canada, once it's been registered for 3 years, it becomes vulnerable to cancellation for non-use. So trademarks are really a use it or lose it game. Even if you have a registration, but you're not using that mark in Canada, your mark can be canceled and you'll lose those rights. So this type of proceeding can be initiated by anyone. It's quite easy, actually. You just file a request with the Canadian Intellectual Property Office, and then they'll issue a notice to the trademark owner. The trademark owner will then be required to file evidence showing that they've used that mark in Canada within the 3-year period preceding that notice. So what do we mean by use in Canada? And particularly for our purposes in the hotel and restaurant context, does that require that there's a brick and mortar establishment in Canada? Or is it possible that you can establish use in Canada even without there being a physical location in Canada? And to help us answer that question, I'm going to turn it over to Peter, who's going to talk about some recent case law that helps shed some light on that question. Peter, over to you.
Well, hello, everyone. For all of you in Canada, I hope you're enjoying your lockdown. For all of you who are currently in the US, please send help. I'm here to talk about probably the biggest case that came out last year, dealing with issues that are going to be relevant to what we're talking about, and that would be Miller Thomson and Hilton Worldwide Holding. And so that is why I am sitting out here in the parking lot in front of one of the closest Hiltons, as you can see behind me. But we're not actually going to be talking about Hilton because that wasn't the issue in the case. In fact, we're going to go over to the Waldorf Astoria. Now I guess I'm in New York, who knows? And not to be confused with Waldorf, Statler and Waldorf from the Muppet Show. You can see that's Waldorf right over there. So what happened was Hilton was the owner of a trademark in Canada for Waldorf Astoria as a trademark, and it had been registered for use in association with hotel services. I'm going to come back to that. Hotel services is important and figures greatly in the entire decision. And so in this case, the appellant, which was Miller Thomson, brought or requested a Section 45 notice be brought. And so that is how this ended up getting to the federal court. And the issue in this case was about hotel services as opposed to hotel registration services. Now, I think one thing to point out just procedurally for those who are wondering why is the law firm bringing this proceeding, these Section 45 notices are very often brought, I could say anonymously essentially, so by a law firm representing a client where that client remains unnamed. So in this case, the registrar of trademarks did issue this notice to Hilton rather, requiring that it provide evidence of use of the Waldorf Astoria as a trademark in Canada in association with hotel services during the 3 years leading up to that notice period. And as I believe most of you know, there is no Waldorf Astoria location in Canada. There was not at the time. There was not for that 3-year period. The history for this proceeding is that the registrar initially expunged the mark, meaning they canceled the mark from the trademark register. It was appealed to the federal court. The federal court overturned the registrar's decision, and then that was appealed once again to the Federal Court of Appeal, and the Federal Court of Appeal upheld the federal court's decision. And so the result is that Hilton gets to keep its registration for Waldorf Astoria. And the key question in this case was, did Hilton established that there was use of the Waldorf Astoria mark in Canada during that relevant 3-year period? And because we're dealing with services, the key question was where were those services performed? You can just move to the next slide, please. So Hilton presented extensive evidence, and this ends up becoming very important to why Hilton wins, whereas in other cases, in fact, one case that we're going to be talking about right afterwards, the applicant in that case, or the owner of the trademark in that case, did not win. So the type of evidence that Hilton presented included that Canadian customers can make hotel reservations through a travel agent, through booking systems, as well as through Hilton's own website. And on the website, Waldorf Astoria is actually featured as a trademark. Canadian consumers could also secure hotel reservations by paying a deposit at the time of booking, or they could get a discounted rate by making a non-refundable payment at the time of booking. And there was evidence that at least 1,300 people did that. You can move to the next slide. The other evidence included that about 400,000 Canadians were part of Hilton's loyalty program, and they could earn points and use those points at hotels. About 41,000 people with addresses in Canada stayed at the Waldorf Astoria. Again, this was all evidence that was put in. And there was discussion of Hilton's plans to construct a Waldorf Astoria hotel in Canada. You can just turn to the next slide, please. Ultimately, the decision was, the Federal Court of Appeal held that hotel services need to be considered in their ordinary commercial usage. And since, and this is now a quote from the case, since the law does not distinguish between primary, incidental, or ancillary services, so in that case, they were referring to reservation services, meaning you can't really operate a hotel without the ability to reserve in advance. Otherwise, people aren't just going to show up on the day and say, any chance you have a room, I just flew in today. Quote, as long as some consumers, purchasers, or members of the public in Canada receive a material benefit from the activity in issue, it will amount to the performance of the service. And so in terms of the key takeaways, the evidence is key. There was a lot of evidence, as I said, and the quality of evidence is going to be very important to being able to show that Canadians derived a material benefit from those services. And so now with that, I want to fly, actually, we'll just take a cab because we're in New York already, to Balthazar, which is one of my favorite restaurants whenever I'm in New York, which has not been for well over a year now. I'm not bitter. If you could just move to the next slide, we're going to talk about the Windygates decision. And this is a Trademark Opposition Board decision. And so the relevant facts are that this numbered company, which essentially is the Balthazar, the company, at their request, sorry, they're not the numbered company, but rather at their request, the registrar issued a notice under Section 45 to Windygates Soho, which is the owner of the Balthazar trademark. And that trademark, just to put this in context, that trademark registration was obtained in Canada by Windygates Soho in 2006. So at the time of this proceeding, it's a 2021 decision, this company, Windygates Soho, the Balthazar company, had owned this mark for, almost, at that point, 15 years. And so they had operated a restaurant in New York City as well as a bakery in New Jersey. There's also a bakery in the New York location. And for anyone who's a big fan of chocolate bread, if you go on a Saturday, they do sell chocolate bread. It's absolutely delicious. Maybe not relevant to what I'm talking about today, but I thought you should know. In any event, the registrar in that case noted that the primary services, which were offered by the owner, could only be enjoyed physically at the restaurant. And the same with the bakery. So they looked at, the Trademark Opposition Board also looked at the quote unquote incidental or ancillary services, which were the ability to book table reservations, the ability to book private events, the ability to purchase gift cards. And it was determined in those cases that they didn't confer a tangible or meaningful benefit to people in Canada. And that was because the website invited you to phone somebody at the location in New York, in Manhattan, to book the table reservation. Same thing for booking private events. You couldn't do it online. Purchasing gift cards, again, they said that they don't deliver the gift cards or bread for that matter outside of a certain specified location. And so mere advertisements of the owner's services through email blasts, through website visits, and other unspecified promotions didn't sufficiently show use or constitute use in Canada. And so with that, I'll turn it back to my colleague, Stephanie.
Thanks. And we'll just be on the last slide here, I think. So just to summarize some tips and takeaways, I'll go through this quickly to make sure that we have ample time to answer any questions. But the first is to plan ahead. One, as I mentioned, because the Canadian Trademarks Office is very slow. And also when you're planning ahead, you'll want to conduct trademark clearance searches in Canada because, as I mentioned, you could have trademark rights in the US, but that doesn't necessarily mean that you'll be able to obtain those same rights in Canada. If, for example, there's already a third party in Canada who's using a similar mark or has a registration for a similar mark. You'll also want to carefully consider the description of services in any application or registration. So trademarks attached to specific goods and services, and those will be listed in your application or registration. The description can be very important. So in the Hilton case that we discussed, the description in that registration was hotel services. It wasn't hotel booking services. It wasn't the operation of a hotel. I believe it was the federal court that said, had the description of services been operation of a hotel, the outcome could have been quite different because it might have been found that the ordinary meaning of the operation of a hotel actually required a physical establishment in Canada. Whereas because the description was hotel services, which is a broader description, it was found that that description hotel services included ancillary services such as booking and reservations. So the registration was maintained on that basis. You'll want to make sure that you use your trademarks. As I mentioned, even with the registration, if you're not actually using the mark, you can lose your rights to that registration. And if you don't have a brick and mortar establishment in Canada, then you'll want to make sure that the service is offered directly to Canadians and the Canadians are able to derive a tangible, meaningful benefit from the use. I think one distinction in between Hilton and Windygates was also that with respect to the reservation services in Hilton, somebody who reserved in Canada, they got a discount. They got the reservation at a discounted rate, whereas in Windygates, that wasn't the case. And so I think the court in Hilton really emphasized the fact that this was a meaningful, tangible benefit that consumers who were in Canada were receiving at the time. And again, as we mentioned, evidence is going to be really important. If a company is facing a Section 45 cancellation proceeding, you want to make sure that you file a lot of evidence because it's really going to turn on that. So that can be website metrics showing the number of times a website displaying the mark was accessed by Canadians, or not just Canadians, but Canadians in Canada, Canadian sales figures, evidence of sales service present in Canada, targeted advertising specifically to Canadians, and also evidence that prices are listed in Canadian dollars. Those are just some examples. Those are the tips and takeaways. Hopefully those were helpful.
Absolutely. What a great, cogent presentation. I feel like I just went through an entire semester of law school on trademarking. How great was that? Thank you both. I've got a couple of quick things. I want to remind the audience to chime in and or through the chat with your questions, but wow. So here's why I want to start. Are you guys seeing what we call in the United States ghost kitchens popping up? David Denny, I just saw your chat. David's our next speaker, and he's a ghost kitchen guru. David, take just a second and explain to everybody in the audience ghost kitchens, and they'll understand why I want to ask Stephanie and Peter about them, because I think they're going to be prevalent there as well.
Yeah, absolutely. They're colloquially known as ghost kitchens. They're also called virtual restaurants or virtual kitchens. So they're commercial food service facilities that don't serve anyone on premise. They're only for delivery and takeaway. And so it's a fully functional restaurant with no servers. Instead of servers, you might have people that bag, sack, and prep items specifically for delivery services like Uber Eats or for people to come to a takeout window.
Yeah, and so I think what I gleaned from y'all's presentation is that since they are delivering directly to people in Canada, right, since it's benefiting the people in Canada in their own backyard, that it would more than likely pass muster, even though they don't have brick and mortar. Does that sound right for our audience who are considering doing that?
Yeah, I think that's exactly right. If the delivery is being provided to consumers in Canada and the trademark is being used, for example, to advertise it, so online, if they're ordering online, then yes, that would constitute use with services in Canada.
I want, just as a different kind of twist on that provision of services, I want to say a couple of years ago, the gentleman who is known colloquially in the US as Cake Boss started actually setting up vending machines in a couple of locations in downtown Toronto, and the machines are branded. They have trademarks on them. I can't recall, it doesn't say Cake Boss, it says whatever his name is, and we had lots of articles because we were so excited to finally be able to try them. But even where you have this a vending machine, there's no human interaction, there's no website component or anything. You just walk up, drop your money in, and pull your machine out. It's the same kind of, I think, thing or process as providing the ghost kitchen service. The only catch, I think, with the ghost kitchen service, and I don't know, Stephanie, if you just said this, relates to whether or not the provision of those services is in some way associated with the trademark. So on the website, you're going to want that. I mean, ideally, you want to deliver your material in a bag with some sort of trademarking on it.
Yeah. Yeah.
If you don't do that, you're dumb. If you don't deliver stuff with a branded bag, you're an idiot.
David is obviously the most diplomatic speaker that we always have join us. But while we're on that kind of discussion phase that he brings to the table, Peter, I do want to remind you that chocolate bread is always relevant whenever you bring it up. Okay. All right. I've got another question I'd like to ask, and that is, in the United States, we had a Supreme Court case actually many years ago. It was 2 pesos versus Taco Cabana, and it was became known as our trade dress case. Does Canada, it's the entire ambiance. Does Canada protect trade dress as well? I think our folks might find that interesting, particularly with some of the unique concepts that we are having built these days.
Sure. I think Stephanie, you were gonna say
Sure.
something?
So it does, although we don't call it trade dress, or at least that's not, a term that exists in the Canadian Trademarks Act. But there are different things that you can protect. So you can protect, for example, the look of the inside of a restaurant, a certain configuration of the tables, that you could file that as I think at this point, I think it's as possibly as a, like, maybe as a 3D mark at this point. So I think I mentioned that there was kind of a complete overhaul of the Trademarks Act that took effect in June 2019, which also added a bunch of different types of trademarks that you can now file protection for. And one of those things was also colors without being applied to any, being applied directly to a good. So you can get registration for a specific color scheme. You'll have to show that that particular color scheme is distinctive. So it might be a little bit more difficult to obtain, but you can do that. And then there's also things such as another new one is position of signing. So the outside of a store, of a retail store, for example, or an establishment, the way that a sign appears on the outside of there. So there is protection for what is called trade dress, but sort of under different names.
Yeah, the other mechanism, certainly the one that I've used in the litigation context, has been to allege common law passing off. And the reason that common law passing off becomes at least available option is because at that point, you don't necessarily have to prove that the collection of elements that constitutes the trade dress are in and of themselves a trademark or series of trademarks. You're actually trying to prove something. I want to say the bar is a little bit lower. You're just trying to prove that whoever it is trying essentially to fool the public or draw some sort of association in the mind of the public between their business and the business of the party that they're, let's say, ripping off, for lack of a better term.
Yeah, that's interesting. That's become a pretty big deal here, and it sounds like it is in Canada as well. I want to shift gears for just a minute, and it's a little outside the scope of the topic, but it's certainly IP. Regarding copyright and, for instance, recipes that have become extraordinarily valuable these days. I know you guys have a different, given what we just heard, the use concept is a little different, right, than what we see here. But in terms of recipe copyright protection, how does that get established in Canada? And does it have to be separately established in Canada?
So I think recipes are an interesting one. I would say that I don't think it's easy to claim protection over a recipe. I think the best thing that you can do is try to keep that as a trade secret, prevent the actual recipe from getting out there. That's the easiest way, I would say, to prevent others from copying that. Other than that, I don't know that there's a clear way to protect it. Pete, I don't know if you have any thoughts on that.
So in terms of couple of points, one of the key distinctions between copyright in Canada, or at least protecting copyright in Canada versus protecting copyright in the US, is that in the US, at least, correct me if I'm wrong, I understand that you actually have to go through a process of essentially proving your copyright. You have to make substantive filings, whereas in Canada, filing or registering a copyright is simply a matter of filing it over the counter, and it's a rubber stamp. They don't look at it. The way I liken it to is if anybody had a friend who was a writer when they were younger, one of the things people used to do is say, send a copy of your own writing by registered mail and don't open it. And that's basically what our copyright registrations do. It's just evidence that you were claiming copyright ownership as at a particular time. I think with recipes, what I would suggest, and I'm thinking, again, I think I'm just thinking of food now because I'm hungry, as we were talking about Balthazar, but Momofuku, which is a restaurant chain in the US, they have a location in Canada, in Toronto, and they sell in their milk bar, which is their dessert kind of section, they have a dessert called crack pie. And the crack pie is some sort of oat, sugar, just delicious thing. In the case of, as Stephanie said, the actual recipe, you'd want to argue that it was a trade secret. You'd want to try and protect it. I think you would be challenged in terms of the originality component to establish copyright. But if you were to use trademark in association with the delivery of that particular product, you probably have a better chance of preventing others from selling it if they're calling it the same thing. The recipe is going to be a tough one though, because I know that it has been argued in Canada, but I don't think it's been argued successfully, precisely because it wasn't considered original.
Right. And actually, I'll add one more thing to that. Peter talked about claims for passing off. I would say that in a case where if you're looking at, say there's two competing restaurants, one with the prior rights, and there's a second restaurant, comes into the market later, and it's the trademark is kind of the same, the inside of the restaurant looks kind of the same, and it's also serving things that are very similar. Maybe it's got a sauce that tastes the same or is very similar. Then it's definitely something that you could try to argue sort of as part of the totality of the evidence in trying to show that consumers are likely to be confused between the two businesses.
That's very helpful. Thank you both. David, you chimed in. Wait, I was just going to tell Peter he should start a food blog, but you're telling me that my favorite pie is no longer being sold? Oh, that hurts me. I'm a big fan of those cake vending machines, though. We've got some cupcake vending machines in Houston, which are always popular around midnight, of course, right? I've heard right after the pot parties break up, but that's just hearsay for all I know. Okay, guys, I just want to thank you again. This has just been terrific information. Thank you so much for joining us and for your Cassels law firm for sharing your time and expertise with us. Really, really terrific information.
Thanks for having us.